So let's begin. Good afternoon, ladies and gentlemen. Thank you for joining us this afternoon. My name is Mbongiseni Buthelezi from the Public Affairs Research Institute. We're very pleased that you have joined us this afternoon, and we're hoping we're going to have a very robust discussion about the Ingonyama Trust in particular, but about institutions more broadly of the nature of the Ingonyama Trust in South Africa at this time, at this point in our history. Let me start by thanking the partners who have partnered with us on this event. I'm from the Public Affairs Research Institute, but the lead partner on this event is the Nelson Mandela Foundation. And we have also had financial support from the Hans Seidel Foundation. I'd also like to thank LARC, the Land and Accountability Research Center, from which two of the panelists come. For partnering on this event. So let me kick off by saying there's some of the questions we want to tackle in this discussion are the following. What are the Ingonyama Trust legal and financial obligations towards its beneficiaries? Where does the Ingonyama Trust Board fit in? What impact has the operations and the administration of the trust had on the land rights and the livelihoods of its beneficiaries? Fourth, has the Ingonyama Trust Board succeeded or failed to ensure that land vested in the trust is administered for the material welfare of its beneficiaries, as its founding act says it should do? How has the board attempted to circumvent accountability for compliance with its constitutional and legislative obligations? And finally, what is the experience of people living on the land administered by the trust, where the trust had or has attempted to conclude income-generating contracts without the consent of its rights holders or of rights holders? Why are we asking these questions now? In 2019, just over a year ago, we hosted the first of these discussions, where we were asking the question of how did the Ingonyama Trust come about? We heard from Hilary Lind, a historian from the United States, who's had unprecedented access, in fact, to people who were involved in the negotiations for the establishment of the trust on the side of the apartheid government, about how the trust actually came about. We're then following up with this discussion where we're thinking about what accountability are we going to see going forward? And we're asking this in light of some events that have happened recently, to which I'll get in a moment. But before I get to that, let's just think back to just a high-level overview of the establishment of the trust and how it comes to be that we have the Ingonyama Trust. The trust was established in 1994 to manage land that had fallen under, well, at the time, it fell under the KwaZulu homeland. It was established by the KwaZulu-Natal Ingonyama Trust Act in 1994. And it was really a deal between the National Party and the Inkatha Freedom Party at the time. What the trust does is administer 2.8 million hectares of land, subject to very important provisions in the act that Zenande is going to talk about in a little while. The act was amended in 1997 to establish the Ingonyama Trust Board that actually does the administering of the land. Again, this is a matter that Zenande and Janet will touch on later. Why is the trust so important now, and why are we having this discussion? I think there are at least three things, just as a way of framing, that we need to be alert to in thinking about the role of the trust. The first one has to do with rights, with people's rights. The Establishing Act, as will be touched on later, is very clear on the requirement of the trust to protect the rights of people living on the land that it administers. These are customary and informal land rights. And the issue that we've seen happen over a period of time, is that these rights are being slowly converted into lease agreements. Which is what, one of the major areas we're going to focus on today. The second thing that is of interest at this point is this question of, in a constitutional democracy like ours, institutions need to serve the needs and the interests of the majority of the people. Institutions, I would say, are not immutable. They change over time. They are adapted as the need arises to meet the requirements of the people whom they are supposed to serve. At this time in South Africa, we are in a phase of institution rebuilding. Think here of the NPA and the Hawks and the work we've seen done on those institutions. I think it's the right time to ask questions of institutions, ask the difficult questions. That also includes asking questions of the Ingonyama Trust. So some of the questions I think we need to ask are, does the Ingonyama Trust serve the needs and the interests of the people whose land it administers? And I deliberately say whose land it administers for a reason I'll touch on later. And we also, I think, need to ask ourselves the question, is the trust of this nature the best vehicle for that purpose of administering the land for the people, on behalf of the people who live on it, on behalf of the owners of that land, one might say? And also, can this trust work better than what we've seen so far, as we're going to hear about in a little while? The third area in our framing, I think, is the question of accountability. Here, I also want to point out that the trust has a very poor track record of refusing to account to Parliament in particular, of obfuscating its annual financial statements, of being very defensive and even arrogant when it's called to account to Parliament. And at the heart of that problem, I think, is a question of sovereignty that I'll return to in a moment. But we may actually have turned a corner. Let me cite two examples of things that have happened in recent times when it comes to the accountability of the trust. In April this year, we heard that the Department of Agriculture, Land Reform and Rural Development was withholding funding for the current financial year for the non-submission of the annual budget of the trust. The Portfolio Committee actually recommended suspending the funding of the trust for failing to account. This is, I think, a major development. The second thing we've also heard is that the Portfolio Committee, chaired by Inkosi Zwelivelile Mandela, has welcomed a probe into governance breaches and violations of the Public Finance Management Act by the trust. This happened in October with a statement released by Parliament on the 22nd of October. Again, I think this is the beginning of turning a corner when it comes to accountability. But I want to end with a thought about the reason why we face these kinds of challenges, the reason why we have to ask these kinds of questions, in my view, about institutions at this point. And that is a question of sovereignty, I think. We face a problem, I think, in South Africa when it comes to traditional authorities more generally, where because of the introduction by colonial and apartheid governments of a state as a political entity that got overlain over the pre-existing political arrangements in African societies, in the post-apartheid period, we're finding where traditional authorities seem to want to think that they have sovereignty vests in them. And I think, unfortunately, what we have is actually a state and a constitutional democracy. And I think that's where the sovereignty vests, that's where ultimate authority in this country lies. So the refusal to account is it seems to me, an attempt to say that because these institutions predate colonialism, predate apartheid, they should not be accountable to a state that has come out of a period of 200 years of colonialism and apartheid. And I think that is a mistake. We have tried in the past to bring into these conversations, into asking these kinds of questions, people associated with the trust itself. I think that would actually be the best way to hold these conversations. But unfortunately, in line with this trend of refusing to account, refusing to be asked questions publicly, we've never been able to have people associated with the trust in these conversations. I'm hoping that in future, we'll be able to have those kinds of conversations. So with that, may I then turn over to our panelists who are going to help us untangle these questions. But in fact, before I do that, let me just say, in terms of discussion, what we're going to ask is that you put your questions in the Q&A box rather than in the chat. The Q&A box it works much better. We've received some questions prior to the event via email, so we will feed them those questions into the conversation as we go along. Some of those are questions that cannot really be answered by this panel. They would be better be answered by people who are associated with the trust, but unfortunately, as I've said, we don't have any such people as part of this conversation. So our three panelists, let me introduce the first one. I'll introduce them each just before they speak. The first to speak is going to be Zenande Boy, who heads activities within the Land and Accountability Research Center in their land research stream. Prior to joining LARC, she was the Crowley Fellow in International Human Rights at the Latner Center for International Law and Justice at the Fordham School of Law in New York City. She graduated with an LLB from the University of Cape Town and completed a master's in international legal studies and international human rights law at Georgetown University Law Center in Washington, D.C. With that, may I turn over to Zenande then? Over to you.
Excuse me. Thank you very much, Mongzeni. I want to start off by thanking the Nelson Mandela Foundation for again holding the space to have this important discussion that has tangible implications for the lives and livelihoods of people that are meant to be beneficiaries of the Ingonyama Trust. Most of them are some of the poorest and most marginalized members of our society. To start us off, I will be giving some context to help guide the discussion that we're going to be having today, which will ultimately consider the powers and functions of the trust, the finances and financial accountability obligations of the trust, and whether the beneficiaries of the trust actually benefit from the operations as is required by the legal framework, as Mongzeni was saying. The bottom line is that the operations of the trust, which I'll touch on, generate significant income for the trust. This income is largely made through the exploitation and development of land that is vested in the trust that it is holding on behalf of its beneficiaries. And to what end is the question, do these people even see a fraction of the benefit derived from the exploitation of their land? Moreover, issues faced by poor rural residents, including those on land administered by the trust, were significantly exacerbated by the impact of COVID-19 and the regulations adopted to curb its spread. People were and continue to be desperate for assistance from institutions tasked with improving their circumstances. Where has the trust been when people at their most vulnerable needed assistance? An important point of departure that we need to move from, as Umbongiseni mentioned, is to sort of talk about the legal framework that regulates the trust. The trust is the creature of legislation. Its powers, the limits of those powers, and the obligations are determined by that legislation, applicable laws, and related regulations. The Ingonyama Trust Act lays these powers and limitations out with some clarity. Important provisions that I want to highlight from the Ingonyama Trust Act provide that the land is vested in the trust, and it is held on behalf of traditional communities and other communities and residents living on the land. These are the beneficiaries of the trust. The land is to be administered for the benefit, material welfare, and social well-being of these beneficiaries, subject to their land rights and other existing rights. As Umbongiseni mentioned, the Ingonyama Trust Board was created in 1997, and it was carried out to carry out the functions of the trustee. Its function is to administer the affairs of the trust and the trust land in accordance with the Trust Act, the Constitution, and Zulu customary law. It is essentially the functioning arm of the trust and exercises the powers that are vested in the trust and the trustee, subject to the same limitations and obligations that would fall onto the trust. Importantly, the Act gives the board no corporate capacity or juristic personality or legal status that is separate from the trust. So what are the powers and obligations of the trust and trustee? The trustee, through the Ingonyama Trust, must administer the land in terms of Zulu customary law, as well as the Act itself. And when something is done on the land that impacts the rights of the land that exist on the land already, examples including the leasing of the land or disposing the land in any way, then before the trust can do anything, it must get the consent of a traditional council or a community authority, as is defined in the Act. But what is more important is that it must comply with relevant laws, and in this case, those laws would include the Interim Protection of Informal Land Rights Act. A PILRA requires that the consent of informal land rights holders be obtained before being deprived of their land rights. Depriving people of their rights to land includes either significantly changing or limiting that right, or the person's ability to exercise that right. Section 2.7 of the Act as well confirms that a PILRA is applicable, and it provides that any national land program shall be applicable on land that is held by the trust. An incredibly important provision that underscores key limitations to the powers of the trust in its administration of the land is that no existing rights or interests shall be infringed by the trust. This ties in with the trust's obligations to comply with the PILRA when it is dealing with the land. What is important and made clear from the provisions of the Trust Act that I've highlighted is that people that live on land administered by the trust are not just holders of rights to land that must be respected and protected. They are also meant to be material beneficiaries of the administration of that land by the trust. So having set out the general legislative framework that governs the operation of the trust, I will be touching on some of the main operations that the trust has been carrying out on land that's vested in it, that it holds on behalf of its beneficiaries. And these operations are the main ways in which the trust generates income and makes revenue for that then goes into the trust. But a number of general questions are particularly important for our purposes today and going forward in having this discussion. One, has the operation of the trust through the board, how has the operation of the trust through the board affected the land rights of its beneficiaries? The second question is, have the trust's beneficiaries substantively benefited from how the land is being administered? Has their material welfare, social well-being been substantively improved directly from the administration of their land by the trust? And three, and this is a question that my colleague Janet will be going into more detail about, but what are the financial and accounting obligations of the trust, and has it been in compliance with those obligations? So in an effort to fill in a gap related to the security of tenure of customary land rights, unregistered rights, and other legally underprotected rights, the trust held by residents on trust land, the trust has been concluding long-term residential leases. Also ostensibly to expedite development on trust land, the trust has been concluding long-term commercial leases with the trust itself as the lessor. So the long-term residential leases are concluded mostly with people that hold pre-existing land rights, either in terms of customary law or in terms of historic tenure, and those are the people that usually fall into the category of beneficiaries of the Trust Act. People that live on land administered by the trust usually hold their land rights in one of two ways. They're either customary law ownership holders, and these ownership rights in terms of customary law are recognized and protected by the Constitution, a PILRA, and no rental is required to be paid when you hold customary land rights. The other way that people generally hold rights to land is through permission to occupy permits. These are apartheid era permits that were given to Black people living on unsurveyed rural land. They were granted in perpetuity. The rights granted were inheritable, and no rent was required for people that held these PTOs. Importantly, in terms of the upgrading of Land Tenure Rights Act, PTOs can also be converted into title deeds. So PTOs have an incredible racist history and are by no means the form in which we should be dealing with tenure in a democratic South Africa. However, we are still waiting for the state to adopt comprehensive legislation and a legislative framework that recognizes, protects land rights of Black people that have been weakened and denied through racist laws. However, these residential leases that are being concluded by the trust are not the answer, because they weaken rights held by people to their land by turning people into tenants on their own ancestral land. Residents are being deprived of their ownership rights to land with no indication that this is being done with their free and informed consent, as is required by PILRA and the Constitution. Also, depriving residents of stronger ownership rights and replacing them with weaker tenancy rights violates Section 25(6) of the Constitution. Residential leases also undercut the long-term land and tenure reform objectives of the Constitution, and any other sort of response that the state wants to make in terms of securing the rights held by people that have been previously unprotected. The residential leases are also a significant revenue for the trust, and its reports to Parliament, the trust has been unable to show how this money that it is making from people actually benefits the residents or communities that hold leases with them and pay rent to them. The trust has also been concluding long-term commercial leases, largely with third-party companies, individuals that are not necessarily part of the communities that this land is located. Sometimes some of these commercial leases are also concluded with community members from those areas. The trust describes this process as being aimed at facilitating and coordinating rural development in KZN. And as a result, when you drive through the rural communities across KZN, you see the landscape changing right before your eyes. Developments such as shopping malls, residential and office developments, mining operations, resorts, and lodges completed or at different stages of construction can be seen everywhere. A significant amount of money is generated from these leases. The trust's website states that the money is used for traditional council support through training traditional councils and providing bursaries for youth in rural areas. There is little indication that this actually happens. Just like the residential leases that I've just spoken about, these leases have the effect of depriving communities of their constitutionally protected rights to land. Long-term leases to mine or to build a shopping center or a resort significantly change the rights that exist over that land, and community members are no longer able to exercise those rights to land or able to access the land or its natural resources that have been part of those communities for generations. There's little indication that these commercial leases are concluded in accordance with the provision of the Trust Act, Zulu customary law, or IPILRA. Community partners that we've worked with report not being informed of intended developments, not knowing the terms of the leases or the impact that the development will have on their land rights and their ability to access the natural resources on this land. In Somgele, for example, people have been moved from their homes to make way for mining. And when negotiations were underway for compensation for the loss of their livelihoods and for having to move to make way for this mine, the mine in question refused to compensate people for the loss of rights to land because they told people that they had a surface lease with the Ingonyama Trust and that they were paying the Ingonyama Trust rent for the land that they will be using for mining operations. Therefore, people weren't entitled to be compensated for losing the rights to ancestral homes, to their plowing fields, and to other parts of the community that they would otherwise have used for other natural resources. These families knew nothing about these leases, how this lease would impact them. They had no idea that this money was supposed to be benefiting them. And the communities are still in struggle trying to get proper compensation from the mine. And the trust is nowhere to be seen to provide the communities the support they need to hold the mine accountable or to benefit from this lease that they have concluded with this mining company. In Makasaneni, which is sort of documented in the documentary This Land, people woke up to find a foreign mining company intending to begin prospecting work on their land. This is land that they've lived on and worked on for generations. They had never been informed of intentions for such development efforts on their land, on their fields. Their consent had not been obtained before any decisions had been made. In that case as well, the Ingonyama Trust had concluded a surface lease with the mining company to allow for prospecting. Rent was being paid for the company to work on the land, but the people who live on it and work on it had no idea about anything related to the operations and the lease concluded over their land. This lack of visibility of the trust in providing substantive and material benefit to communities that host these developments that it makes money from is par of course under normal circumstances. However, their absence was felt even more sharply in the communities that we work with, who bore the brunt of the impact of COVID-19 and the regulations that were adopted to curb its spread. Community members gave accounts of not being able to access food parcels, services like water and sanitation, and other relief efforts in response to COVID-19. There has been no indication that the trust has been anywhere to be seen in this time of immense crisis in the communities that are forced to host developments that generate a lot of income from it. So I'm going to hand over back to Umbongiseni, and my colleague Janet will go into more detail about the financial obligations of the trust and issues that have arisen in attempts to hold it accountable for the money that it makes on the land it administers.
Thank you, Zenande, for that overview. I think it leads quite nicely into what Janet is going to talk about. So just to introduce Janet briefly, she holds a BA LLB from the University of the Witwatersrand and is an attorney. She is an experienced property lawyer and was director of a Cape Town law firm where she combined a diverse commercial and property law practice with an interest in water law and restitution of land rights. She's currently involved in research in this field and is in the interpretation of fiduciary duties of state land trusts in post-colonial jurisdictions. She's also a research associate of LARC. Janet, thank you. Over to you.
Thank you, Mbuseni. Good afternoon, everyone. It's very nice to be here. As Zenande, my colleague, has mentioned, I'm going to be detailing aspects of the issue of accountability in relation to the Ingonyama Trust and its board, and probably dealing with very more specific details rather than practical examples. But I think just to frame what I'm going to say, I think it's important, as both Mbuseni and Zenande have mentioned, that it's important to view the question of accountability in the context of beneficiaries of the Ingonyama Trust. These are the members, the tribes, and the residents listed in the Act. The beneficiaries are the primary stakeholders of the trust, and in terms of the Act, the trust must be administered for their benefit, material welfare, and social well-being. As Zenande mentioned, the leasing practices on trust land indicates that the trust, under the leasing approach, has accumulated significant reserves, yet with what seems to be a significantly low ratio of distribution of these reserves to beneficiaries. It's important to understand then how the Ingonyama Trust Board, who is the financial reporting authority for the trust, reports income and how they report distribution to beneficiaries. This brings us directly to the question of accountability. Now, the Ingonyama Trust Act does require a high level of accountability. The Ingonyama Trust Act has attached to it a set of administrative and financial regulations, and the financial regulations specifically apply to all income earned or accrued to the trust, and which is subject to the provisions of the Public Finance Management Act, the PFMA, as I will call it, going through this short presentation. Now, the PFMA is an important act. It sets the rules for how state entities report on public funds that they use. Its purpose is to secure transparency, its accountability, sound management of revenue. And important to this forum, I think, is the issue of accountability, in that we have noticed in our research that the Ingonyama Trust Board has developed a position that, save for one Treasury regulation, which we can talk about in our chat afterwards, which is Regulation 14, the Ingonyama Trust is not subject to the provisions of the Public Finance Management Act. How can that be, one would ask? But it seems that the board appears over the years as the accounting authority for the trust to have regularly complied with the provisions of the PFMA until 2015-2016. However, in 2015-2016, the Auditor General queried the way in which information was presented, and the Auditor General expressed concern that the accounts for the trust and that of the board had become conflated. And this made it difficult to identify which income and expenditure was for the trust and which income and expenditure was for the board. The Auditor General issued an adverse opinion that year and asked the board to provide separate financial statements for the two entities, one for the trust, one for the board. Now, this led on to an interesting sort of series of events. And it seems that, and from our reading of what happened, looking at the annual financial statements, parliamentary committee meeting minutes, it seems that the board has interpreted this to mean that the Ingonyama Trust and the Ingonyama Board are two separate legal entities. This interpretation actually has profound influence on budgetary requirements, as well as the status of the trust and the trust obligations under the PFMA. The board goes on then to argue that therefore the provisions of the PFMA do not apply to the trust. The board's interpretation seems to be based on the fact that the PFMA includes a schedule of state-funded entities that are bound by its provisions. This is a schedule attached to the PFMA. This schedule includes the Ingonyama Trust Board. However, while it is true that the name of the board is listed on the PFMA schedule, this is because it is the board that is the accounting authority of the trust, and it is the duty of the board to prepare and present PFMA compliant reports for the trust in terms of the financial regulations. So I think what we're saying here is that they are dealt with, the board and the trust are separate, but they're not a separate entity. In fact, this matter came to a head in 2017, and the then Minister of Rural Development and Land Affairs obtained a legal opinion which clarified that the Ingonyama Trust Act created one entity, and that is the trust, with an administrative body, which is the board. Zenanda has already explained this structure. In other words, the board and the trust are effectively one entity in which the board exists only to perform administrative duties of the trust. In effect, it would not exist if it were not created in service of the trust. Nonetheless, the board has pressed on with its interpretation. In fact, in the Auditor General's opinion in 2018 and 2019, this gives the clearest indication yet that the board is entrenching this notion. It states that with reference to the Ingonyama Trust, we submit that save for Treasury Regulation 14, the provisions of the PFMA do not apply to the trust. Their submission is based on or premised on the following arguments: that the trust is not a public entity under the PFMA, that it does not receive any funding from the state, that is neither a constitutional institute or a government department, and it is only associated with state by virtue of being created by a statute. I want to briefly, because I think this is really important, just respond to these arguments by pointing out a couple of things. The first is that the trust is a national public entity. It's publicly funded through money that the state bears. The state actually bears for the cost of the administration of the board. That is in terms of the Ingonyama Trust Act. The Ingonyama Trust is established by national legislation. It's accountable to Parliament. An important note is that the trust benefits significantly from an exemption for paying income tax in terms of Section 10 of the Income Tax Act. There are further losses that result to the fiscus as a result of this. Zenande mentioned lease income. Commercial lease, for instance, is not taxed in the hands of the trust, and rental would be allowed as a deduction by the lessees. It's also important that the Constitutional Court has held that the trust is an organ of state, stating that there can be little doubt that the trust exercises public power and performs functions in terms of legislation. If one looks at the Constitution, an organ of state is any department of state or administration in the national, provincial, or local sphere of government. It's important also that the Constitution places basic values and principles governing public administration of organs of state. Zenande mentioned that it is clear that the trust is linked to the state. The Trust Act specifies that the minister is the executive authority of the trust. It specifies that the trust must report to the minister and to the Parliament on its work every year, and it specifies that the trust land will be subject to any state land reform program. The Supreme Court of Appeal has also ruled that it cannot be that the trust is not part of the state if it's part of a state land reform program. Moreover, in terms of the Act, the Ingonyama Trust is exempt from the provisions of the Trust Property Control Act, and it seems inconceivable that an entity which has been entrusted with 2.8 million hectares of land is not subject to any oversight at all. Now, why does this matter? As Nandi has mentioned, the Ingonyama Trust holds assets worth hundreds of millions of rands on behalf of people on the trust land for their benefit, material welfare, and social well-being. Therefore, the trust should be disclosing exactly how much revenue there is in terms of, for example, leases, commercial ventures, tourism ventures, forests, and quarries. It should be public knowledge what this money, which is being held in trust for the people, is being expended for the benefit of its stakeholders. If there's inadequate reporting of revenues and expenditure, it's impossible to know where the money is going. As Mbogisendi also mentioned, to their credit, MPs have played an important role in asking questions of the board and the trusts and Parliament's Portfolio Committee of Rural Development and Land Reform over the years has repeatedly tried to clarify whether the trust mandate to provide benefit to communities is being upheld, with little success. As far back as October 2016, the committee asked the minister to ensure that the board comply with reporting on all funds, irrespective of where they were sourced. It asked the minister to help the board to draw up a report on the impact of its beneficiary programs going back 5 years. In October 2019, the board was asked for clarity on the 10% fee that went to the board and the 90% that went back to the community. This is a reference to the Ingonyama Trust Financial Regulation 10.2, which allows an amount of 10% of the trust income to be utilized for administrative purposes. Again, a 5-year report was requested. In May and June this year, this request was repeated by the chair of the Portfolio Committee meeting. These reports have not been provided. Parliament, as has been mentioned, has now withheld funding for the board for the 2021 financial year while it waits for the board to deliver the information it has asked for. I understand that the minister has appointed an interim board and also has instituted a forensic audit. But where are we going forward? Perhaps for the sake of clarity, and so as to avoid confusion which seems to have risen, the schedule to the PFMA should be amended and the name of the trust added to it. The PFMA provides on unlisted entities that the accounting authority, in this instance the trust board, of any national entity that is incorrectly or not listed under the PFMA is under a legal obligation to inform the minister that the entity should be added. This is something that the board should do. The Minister of Finance also has the ability to do this by making a provision in the Government Gazette. In conclusion and in short, what we have found in reading the annual financial statements is that distributions to beneficiaries are vaguely reported. They're given very little relevance with little or no mention of how distributions are put to use. Arguing that the trust is not accountable under the PFMA is concerning, and it's a red flag. It permits a lack of oversight and transparency over the nature of trust funds and the allocation to projects that will benefit the principal stakeholders, these being the beneficiaries of the trust. I think I'm handing over back to you, Mbogisendi, but I'll do that.
Thank you, Janet. There are some interesting questions already popping up in the chat, but one I want to just feed in now has just been posed by Mashile Palani. Mashile is asking, where does the Ingonyama Trust land stretch from? And does that include urban towns like Durban? So those 2.8 million hectares that we're talking about, which part of the province do they cover?
Okay, the Ingonyama Trust land is, because it flows through from the former homelands, is non-contiguous. So it's patches all over the province of KZN. It specifically excludes urban towns. So that's specifically excluded in terms of what was excluded in terms of the Amendment Act. So it's pockets of land really all over the province of KZN.
Thanks, Janet. I think at this point, I'll bring in our third panelist, and then we'll circle back to the questions. The third panelist, our invitation had said Reverend Mbexeni Mavuso was going to be the third panelist. Unfortunately, in Makasaneni, where he is, outside Melmoth in KwaZulu-Natal, he's having very, very bad connectivity. So thankfully, we have Lerato Ndombela, who's also an activist from KwaZulu-Natal. And in line with what Janet has just said about where the land is, she's from Ezingolweni, which is way down south in KwaZulu-Natal. So Lerato, if you could tell us about your experience with the Ingonyama Trust. Thank you very much.
Hello. Hello.
Hello, Lerato. You're live. Go ahead, please.
Okay. Afternoon all. Here at KZN, in fact, this problem for the trust is affecting the community of KZN. In my community, there are people who pay in the Ingonyama Trust, and also the Ingonyama Trust didn't do anything for us, like building schools, churches, donating to the people who are poor or who are in need.
Lerato, sorry, we're just struggling with your sound. Do you want to just move around a little bit? Maybe we'll get a better sound from you.
Hello? Hello?
Well, there's an echo in the background. I'm not sure what that is from.
I can't hear you.
Okay, carry on. Thanks.
Okay. So what I see here, the traditional leaders, they trust the Ingonyama Trust here in KZN. If as we are the community, when we try to talk about this thing, paying money, the leave, paying leave, they want us to take leave. They go door to door so that we can take the leave. Others, they take it, especially those ones from government, who work from government. Those ones who, when they want a subsidy, they go to Ingonyama Trust and then they pay every year this money. And also, if you want a business here, you pay to Ingonyama Trust. For example, there's a lady who got a land from our chief. So who could pay, whereas she didn't do anything. She didn't give. In fact, she wanted that land to build a garage, a petrol garage. But she didn't give for now it's for 5 years now. But she paid that money to the Ingonyama Trust. She pays every year. I think she pays about 38,000 to Ingonyama Trust. But there's nothing there, nothing. She didn't start a business. I am concerned about this issue because I didn't hear anything from our government. What the state should take about this issue. Yes, we hear Tungutiza, we hear Mandela, but the others, especially the traditional leaders, I don't know the behavior of the people, of their people who are supported by the Ingonyama Trust. Our businesses here, we pay for our businesses. We pay for our lands. I don't know, government, what action government take it about those things of paying for our lands. And also, if I am government, I can say the Ingonyama Trust may pay the traditional leader and the headman. Because there are a lot of money that they get, but they didn't do anything in our community. Why don't they pay the traditional leader and their headmen? Government mustn't pay these people. Government must take this money and do the development in our community. Because we need clinics, we need hospitals, we still need schools and colleges. We don't have all those things. But there are a lot of money goes to the traditional leaders, whereas they don't do anything in our community. Even the traditional leaders, the traditional leaders, the chiefs, they don't do anything. They don't contribute. They know there are people who are suffering, but they don't contribute to anything. They just collect the money to the poor people. I don't know, government can take that or can look for these things that is happening in our community, especially in our area. We are suffering. We pay. We don't work. We don't work. We don't have money to pay, but they force us to pay. They force us to pay. Anything. If you've got a tuck shop in your house, they say you must pay for that. Thank you.
Thank you, Lerato. So the issue I'm hearing here is that, so to speak, we've just heard from the horse's mouth, so to speak. People are being asked to pay on their own ancestral land. And as Lerato is saying, they're not seeing the benefit of this money that they're being asked to pay. The figure of 35 to 38,000 Rand being paid for what is a commercial lease, and everybody who has a little tuck shop having to pay when they are trying to eke out a living. Lerato is calling for a government intervention. Government needs to intervene to stop these things. We also have a lot of other questions that have come in, fantastic questions. Some of them are in the Q&A. And if I could just remind everybody, instead of using the chat, please use the Q&A box. The Q&A box works much better. But I'm going to start, and I'm going to take the questions in clusters of 3. Some of them are actually not questions, they're just comments. We've received some questions from people who sent them in via email. I'll start with the 3 that we've received. The first is, and somebody's asked a similar question in the Q&A, what are the implications of the trust for other ethnic groups in different provinces? The person is saying, I think they would also like to get assistance in the way that the trust is getting from government. There's a similar question in the trust, in the Q&A, asking what does this mean, in fact, for the country more broadly, to have a trust like this in KwaZulu-Natal. I'll also throw in another question related, which has just come in, which says, does the eThekwini municipality have any say in the Ingonyama Trust land in terms of land use management powers and how these powers are exercised? So let's think about, let's just ask that question. I'm going to direct it to you, Zenande, to kick us off. The second is actually 2 questions. It's about the farms in particular that are vested in the Ingonyama Trust. The person is asking, this is Nono Msani, why doesn't the trust lease these farms? They are just unoccupied and are being vandalized. The second question is, why doesn't the trust follow up where Izinduna illegally subdivide farms into portions and sell them to communities for between 50 and 100,000 Rand per plot of land, even when community members have reported these matters? And the third one comes from somebody who would like to remain anonymous. I wish to know, according to the act that guides the nomination of people to become members of the board, and this is for you, Janet. How long can a person serve on the board? And the reason for this question is that since the inception of the ITB, it seems like the same people are still on the board. One would think that they actually own the trust. So let's start with those. I'm going to ask you, Zenande, to kick us off.
Thank you. So on the first question around the implications for this trust for sort of other traditional communities and other provinces. So, I mean, this is also something that the portfolio committee chairperson, who Mr. Mandela was speaking about, was saying, well, if the trust so we need to sort of be looking at this trust. If this trust is a good way of dealing with land, then this trust should be something that's replicated across the country. So, I mean, there are sort of many issues with that, in that the trust itself, I mean, even from the conversation that we'd had before around why the trust was created, it wasn't really created for the purposes of actually protecting people's land rights. It was from what we heard from the research that Lynn did, is that it was really just a political concessions made to make sure that our transition period moves forward. But the problem with that is with sort of trying to replicate this model is that really trusts aren't a very good way of protecting people's rights. And that's what we need to be doing in terms of Section 25(6) of the Constitution. People that have insecure tenure rights need to have those rights made secure, and they need to have those rights protected. Now, the problem with how a trust works and trusts being beneficiaries is that there is no clarity really about how people's rights exist. You're seeing the same issues come out in the CPAs, where you have land being transferred to CPAs, but the individual land rights that are held by individuals, families, smaller communities, and people that aren't necessarily very powerful inside communities, those rights aren't really recognized. So what we need isn't to be replicating the Ingonyama Trust. What we need is a proper and comprehensive legal framework that exists to protect, recognize the rights of people and the land, that, like the rights of people in their land in the way that it actually exists. So just seeing how the issue with the trust and its operations now, how hard it is to hold the trust accountable for its operations, how hard it is for individual community members to have their rights recognized and protected. This isn't something we want replicated. What we need is for people to be seen as individuals and stakeholders in their land, and communities to be seen as rights holders in their land, and for us to protect those rights. And not try to sort of give them over to some entity. I mean, Sombongiseni, in the beginning, you were speaking about how colonial governments came and imposed this sort of state above what was existing in terms of traditional leadership institutions. Another aspect of colonialism was this idea that Black people do not own their land, that Black people do not hold the rights to the land, and they're not capable of doing it themselves. We need to dispel ourselves of that. We need to recognize that individuals, communities, families have been holding rights to land for generations, and we need to find a way to protect that and to recognize that, and to give people agency and to give people their ability to control their lives, instead of trying to create these institutions that hold rights to land on their behalf. That's what colonialism and apartheid was doing. That's what the apartheid government did. Apartheid government didn't give Black people their rights to land. It held them for them and said, you guys can't hold that, and we need to move away from that. This trust isn't an answer in any sort of way, because again, it prevents Black people from having rights to land, to hold and to control and to make decisions for themselves. So this is definitely something that we should not be considering as something that can be replicated across the country. So on the, I'm going to let Janet take the eThekwini question, but from my understanding, no, the eThekwini municipality has no control over how the trust operates on land that's vested in it. I think there's been previously some conflict and contestation of land, whether or not land is actually vested in the trust or it's not vested in the trust. So as Janet was mentioning, that in terms of the Amendment Act, urban land isn't vested in the trust. It's mostly rural land in pockets across the province. But there is sort of overlap where there's questions about whether or not, for example, land vests in a municipality or in the trust. But then outside of that, municipalities and the eThekwini municipality have no say over how the trust acts on land that's been vested in it. I'll let you come in now, Janet. Just on the farms. So again, the problem really is the fact the farms that are vested in the trust and whether or not the trust should be leasing them. I mean, I hope from my presentation, I made it a bit more clear that we don't want the trust unilaterally leasing land out, even if it's vested in them, because that has huge implications for people's rights to land. KZN so South Africa doesn't have pieces of land where no one has any rights to it. So these farms that might be vested in the trust in terms of like the title deed still have people that do have rights over that land. What we need is a proper process of ensuring that people can actually use the land that they have, and that people are able to access that land, so that land doesn't lay bare with no one using it in any way. So I'm going to let Janet come in on the other questions.
Yes, just on the eThekwini issue. Yes, the Trust Act did exclude urban areas, but just because of the way and wall-to-wall municipalities have existed, there are aspects of Ingonyama Trust land that do seem to fall into some municipalities, and that has raised other issues. For example, whether or not rates are payable. To be honest, I'm not sure how this works in and around eThekwini itself, but generally the Act did exclude urban areas. So, and there were the old R294 townships, I think, but generally those have been or on the process of being transferred. Just coming to the question of, I just want to have a look here, about the farms. Yeah, I agree with Sananda. I think that's probably something that we want to move against and move away from, and have a more overarching policy than sticking to the sort of trust model that has filtered through over centuries from sort of British colonial sort of practices, and so that I agree with her on that. I think the question about one of the panelists asking about members of the board. Yes, that is correct, that the members of the board have been, I mean, if you look from one financial year to the next, it's the same members on the board. As I understand it, though, that just recently this has changed and that the minister has appointed an interim board. I'm not sure how that is flowing through at the moment. Whether or not somebody could be appointed to the board. Generally, the 8 out of 9 members of the board are appointed by the minister. This is in consultation with Ingonyama, I think also with the KZN legislature. I think generally over the years it's been a rollover, but I think at the moment now there's been heightened interest in the board, and that you know, and in fact that's a good example of how the Ingonyama Trust is irrevocably linked to the state, in that the minister has the power to appoint the members of the board. I hope that answers the question.
Thank you both. Lerato, is Lerato still with us? I'm not seeing her here anymore.
I don't see her either.
We seem to have lost Lerato. I was going to ask if she had anything she wanted to respond to, but let's then take the next round of questions. There's been, I mean, there are a lot of comments. Let me feed some of them in, and then some questions. The one comment is, government is failing communities on rural land throughout South Africa. Land that the government owns throughout South Africa. Why this focus on the Ingonyama Trust is the question. There's a question from Fatima, that question is from Baron Beatrice Ace. Fatima Osman makes this point. I wonder if you have a better way to regulate customary land rights. It seems part of the reason the trust operates is because of the gap in the law. Like you said, land is held under old land regimes. None of the newer state interventions have been successful. Could you propose a better way for land rights to be held? Emily Kyale says, how is this trust going to solve the issue of securing tenure for individual land rights holders, some of whom have papers? She also says, is there any provision made for upgrading the tenure rights for beneficiaries who live within the jurisdiction, some of whom have PTOs, etc.? And her third point is what is the composition of the trust? Is there beneficiaries? Is there beneficiary representation, more especially women? Let's look at one more. Gaino Parazza, my colleague from Paris, says, thank you for this illuminating webinar. Are there any safeguards for the community land rights? To what extent does the Kolobeni precedent provide an opportunity for communities to defend their land rights? Let's take those, and then we'll probably have time for two more rounds of questions and comments.
Okay. Just on the question around the general failure of the Department of Government and why we're focusing on the trust. So, I mean, we're not focusing on the trust. This particular webinar is about sort of the trust, but the work that's being done by rural activists across the country are continuing to hold the various government departments, the Department of Rural Development, the Department of Mineral Resources, all these departments that have in some way a role to play in administering communal land or customary or land held by customary communities. There is ongoing work around sort of dealing with and trying to hold the state accountable for their failures to hold institutions accountable, to hold traditional leaderships accountable, to ensure that private institutions and development companies are respecting people's rights to land, and to ensure that people are actually protected and their land isn't taken away from them. I think the unique situation, I mean, but we can't, regardless of sort of the systemic failure of government and failing to really respond and protect people against land dispossession, I think we can't deny sort of the unique position of KZN with the trust. This trust is the only one that exists in the entirety of South Africa. It holds millions of hectares of land. It generates millions of rands in income from how it's using this land. So it's important to highlight this institution as well in the ongoing general attempts to hold government itself accountable for how it's been responding to the impacts of insecurity of tenure in people in rural communities. Yeah, so I think I've answered that question. So in terms of a better way to hold customary land, sorry, and just also another thing, I think it's also important to be having continuous conversations about the trust, just to highlight the sort of shortcomings on, so I mean, there are different ways in which land can be held. And I think sort of really getting into the issues and the problems with specific institutions and specific ways that land is being held is really important, because the state is sort of moving through an ongoing process of adopting legislation and creating a framework that's supposed to comply with Section 25(6). So seeing how CPAs work, seeing how the trust works in KZN, and seeing how other institutions are working is an important conversation that we need to be having in sort of framing how in future we'll be dealing with tenure and security in the former homelands. Sort of a better way in which to hold land. This is, I mean, I guess this is the million-dollar question of, so we have all these things that are clearly not working. So what is it that we do to make sure that it works? I think the point of departure, which we're seeing that is lacking in the creation of trusts and in sort of the various iterations of laws that the Department of Rural Development seems to be sort of taking in framing legislation and in framing the legislative framework is sort of this idea that people in rural areas have no way or have no systems in place, that we need to be putting systems in place for them for how they deal with their land and how they hold their rights to their land, how they protect themselves against institutions that try to sort of take their land away. So I think the point of departure is really speaking to communities and speaking to people about how is it you believe would best protect you against having your rights taken away from you, instead of sort of sitting where government sits in offices and says, okay, let's do CPAs, let's do trusts, let's transfer this land to traditional authorities and traditional authorities will deal with that. Conversations aren't being held with people who are actually live in terms of customary law, who actually hold lands to right in terms of customary law. I mean, whenever we're at public meetings or public hearings looking at legislation that in some way impacts customary land rights, people over and over say, I don't understand why we're being brought this piece of legislation that we've never heard anything about, that goes completely at odds with how our systems actually operate. So I mean, I don't live in terms of customary law. I don't hold my land rights in terms of customary law. So I think the question should be sort of posed to people who actually do so, because they're best placed to understand how their rights work and how to best protect them. And then in sort of a dialogue, we're able to then start thinking about, okay, well, this is how people who live in terms of the system say we should be dealing with their land rights. How then does that fare with the threats that exist? And sort of how then do we sort of place this in a context that where title deeds exist, where the deeds registry office exists, where development companies want to come in and mine and build lodges and do all of these things in the context of that. So there's a balancing act that needs to be done, but the conversation shouldn't be had with just government officials, with just NGOs, with just experts. It should be had with people who are actually living in terms of these systems, because they're best placed to understand how best to make sure that they're not getting the short end of the stick, which is basically what's been going on for the past hundreds of years. So in terms of the safeguards, so I mean, the problem with the safeguards that exist for communities is that they're not implemented. So we have Section 25(6) of the Constitution. We have the Interim Protection of Informal Land Rights Act that recognizes that people hold rights in terms of customary law, that people hold rights in terms of different group tenure systems, and those rights are valid property rights that are the same as people who hold title deeds. However, that's just not being implemented. I mean, I think the Xolobeni example is a great example, because I was the first, the Xolobeni community had to go to court for the court to say that these are people that hold property rights, these are people that hold land rights that need to be respected. And before you make a decision about what to do with that land, you need to speak to them and get their consent. That was the massive thing that happened in Xolobeni just a couple of years ago. So this is with the Interim Protection of Informal Land Rights Act existing since 1996. So, I mean, so we have a good constitution, we have a decent IPILRA. I mean, IPILRA has massive shortcomings, and we need a permanent and more sort of a more thought out and fleshed out framework to deal with these land rights. But the protections and safeguards that exist right now are just not being implemented, and communities are left on their own to try and protect themselves against mining companies, against developments who don't see their rights to land as valid property rights that need to be respected. So I'll just stop there and let Janet come
in. Sorry. I think I'd like to deal with the question of one of the questions about whether or not the beneficiaries of the Ingonyama Trust have any say in respect of the trust or on the Ingonyama Trust board. I think this is a really important question. Just structurally, before I go into that, just to say that the Ingonyama Trust has one trustee, and in 1997, a board was created to assist in the administration of the trust, which is obviously a huge landowning trust. And the short answer to the question, no, the beneficiaries don't have any say in what happens on the board or with the trust. And that's one of the issues why when we raise the question of accountability, it is really concerning that there's these attempts made even to circumvent what protections are already in place in terms of the Public Finance Management Act, which allows, which prescribes that public institutions must provide the proper, must be transparent and provide proper information to enable stakeholders to, to have a meaningful input and to see what is, being done with public funds. And on that point, I think that's something that could be explored. I think there should be an examination, an important public examination of what information should be available and necessary for all stakeholders to adequately satisfy, their desire to see what's happening with the money, and perhaps even have some form of representation, on this board. So I think that is a really important point, and perhaps that is the problem, that there's a complete disconnect, it seems, between the board and beneficiaries, or people that are subject to decisions that are made by the board on their behalf. And it goes even further, where beneficiaries have told us anecdotally of trying to find and get information, having to travel for long distances to Pietermaritzburg to have discussions with the board, only to find that they can't see the right person and to have to come back. There doesn't seem to be a proper public forum for people to raise their concerns. If people who the board, even in their annual financial statements, say that if communities want to access funds, for instance, they have to request business, have to provide business plans, and very much a bottom-up approach rather than a proper thought out programs for communities on the ground. And I think that beneficiary representation on the board, or some sort of forum, I think that would be really important, and an examination about this really has to take place.
Thank you. I've got some great comments here. I'm going to just read into the discussion, which I think responds to some of the things that have just been said and some of the questions we've asked. Mary De Haas, who's a long-time researcher and activist in KwaZulu-Natal, has this to say. She says, this is mainly a comment. Parts of the eThekwini Metro are part of the trust, e.g. peri-urban rural areas, and there's a struggle going on about people living on land without paying rates. So perhaps Janet would like to comment. In many areas I work in, there's no transparency about what the trust is doing. It has given a lease to someone in Mpembeni near Richards Bay, and people have been told they must move for oil, yet no details at all are given to them. So there's clear collusion between the local traditional leadership, and money given by the trust to the traditional council never filters through to the community. Mary also says, surely this trust is unconstitutional, as it discriminates against people in this province and those in others where traditional leaders don't have their own trusts. There's a comment also, this is also from Mary, who says, please tell everyone that the chair of the board, Jerome Ngwenya, is a director of Zululand Anthracite Colliery, which has leases from the trust, and the conflict of interest is ignored. This mine caused untold hardship to the community, and even children are protesting and saying the mine is killing the nation. There's another comment, which I'm just trying to find here, from Desiree Erasmus. It says, Jerome Ngwenya, who's the chairperson of the board, is often said to be one of the stumbling blocks to getting the trust to function according to the PEFMA. Do the panelists agree with this? And why is Mr. Ngwenya repeatedly made chair of the board? Does the minister not have a say in this, along with the KZN Premier? How then would the government intervention make the trust better? There's also a set of questions which I'm not going to read out, but there's a question about what is the relationship between the trust and other traditional leaders in the province? Is there a relationship? How does that function? And also, just let me read two more. There was an early question, actually this is a comment from Spesihle Sihlali. The policy and regulatory gap also requires law reform. A Community Finance Management and Development Act could go a long way to give community members the tools to hold to account their community structures, whether a CPA or a trust, a customary law institution, a traditional council under the TLFGA, B, the state at all spheres, but in particular local government with responsibilities towards customary communities on communal land. And third parties such as mining companies, shopping malls, agribusiness, etc. The PFMA and the MFMA provide examples of reporting, procurement mandates, and so on, but more is needed. There's also a comment from Spelele Mdagane, who says, good day, what steps have been taken to convert permissions to occupy to title deeds? Will this conversion automatically result in the rating of the properties causing residents to be responsible for municipal rates and taxes? Let's take those. We are moving towards a close. So I'm going to ask you to respond relatively briefly so that we can get in another last short round of questions. Janet, okay, you do want to go first?
Yeah, I can just quickly go first.
Zenanda, okay, go for it.
So in terms of the relationship between the trust and traditional leaders, so I mean, I would say that it depends and it varies from community to community. Some traditional leaders have no relationship with the trust, and some traditional leaders have a problematically close relationship with the trust. And I think, so I mean, so in terms of the communities that we've worked with, some traditional leaders are really against the charging of leases because they never see any sort of money that comes from leases or any sort of benefit that comes from the leases that are being charged from community members in their community. But I think what's also could be an indication of the type of relationship between the trust and the traditional leaders is that the basis of the audit that the minister has sort of instituted is as a result of many traditional leaders complaining about bribes being paid, about them not benefiting from developments that are going on land that are within their jurisdiction, and sort of going to the minister and saying that they're having a problem with how the trust is operating on land that falls under their jurisdiction. So one, that can be an indication of how people are, how traditional leaders and the trust are also interacting. But I think one thing that's particularly that I find concerning in relation to the fact that it's in response to complaints by traditional leaders that this audit is now coming, is that communities have been complaining about the operation of the trust almost since its inception, and really only it's only when traditional leaders are saying, well, I mean, I'm not getting a big enough slice of the pie, or other people are getting bribed, and maybe I should be also getting something from all this that's going on the land. Are we now seeing the minister sort of saying, okay, we're now going to do an audit and we're not going to look deeply into the financial operations of the trust? I mean, the trust has been having adverse Auditor General sort of conclusions for years now. And communities have been talking about how they are losing land, that they're being moved from land for the purposes of these developments, and sort of nothing happening. So I think the audit thing is a good sort of is a really great development, and sort of the support of the portfolio committee is a great development. But then now I just find it really concerning. Who are we actually listening to, and whose grievances and issues are we responding to, if it needs to be traditional leaders as opposed to communities who have to be raising issues before substantive steps are taken to hold this trust accountable. So Mary's comment is unfortunately a very sort of, this is exactly what happens in too many contexts where people are told of vague instructions that you guys are going to have to move soon. We're going to be building a mine, or we're going to be building a lodge, or we're going to be mining in some sort of way, and we're going to be doing it on your land, and you need to move with no consultation, with no indication of where people are expected to move to, with no indication of what compensation they're going to be getting to replace the livelihoods and the land that they're using, and with no engagement and working together to figure out like whether or not this is even a good thing for the communities or KZN in general. So with the PTO and title deeds, so there are many issues with the upgrading of land tenure rights act, the one that sort of sets out the processes of upgrading tenure, upgrading PTOs and deeds of grant to title deeds. One of them being the fact that the biggest sort of issues in relation to that is really the fact that having a title deed completely erases the existence of other rights on that land. The title deed can only be in the name of one person, and doesn't take into account the nuance that exists in how traditional communities hold their rights to land. And then there are the real questions of like, okay, so if you have a title deed, what does that mean in terms of things that you're incurring? What costs are incurred as a result of that? So the reality is ULTRA, which is the Upgrading of Land Tenure Rights Act, was never really a response to the systemic security of tenure issues. That was an apartheid era piece of legislation. That was a band-aid that the apartheid government was putting in to make it seem like they were doing anything in respect of the really bad tenure situation that they created with years and years of racist laws that refused to recognize the validity of Black people's rights to land. So that entire process is not a thought out process, and it doesn't respond to the issues that exist. So the operation of ULTRA and the upgrading of PTOs and all these other rights to title deeds will just be creating more problems because it doesn't respond to the issues at hand. I think that's it. I think the rest were comments.
Janet, do you want to have anything to add?
Just to add on Mary's comment, that's her comment about monies filtering through to the beneficiaries on Ingonyama Trust land is precisely why we had a look at, because this is what obviously we could see, it can be seen on the ground, which is why we then looked to see how it was being reported in annual financial statements, and then seeing that it was completely vague and sort of it's not only vague, it just seems to be of little relevance in the annual financial statements. Was really disappointing, and that is why this question of saying that the PFMA doesn't apply to the trust must really be addressed, and quite urgently, I think. And then just a quick answer to the one question about whether or not you have a title deed and would it be automatically, a PTO, and would it be automatically upgraded to a title deed? It would only automatically be upgraded to a title deed, and this has sort of happened, as Zinande mentioned, because of the upgrading of Land Tenure Rights Act, which, as she said, was really a type of band-aid, and it did have some unforeseen consequences. One of those was an automatic upgrade, and that normally happened. That act is very much based on a survey, on the basis of having a survey available, which is expensive and which it can be complicated, but in certain areas those were in place because of township surveys, and that resulted in automatic upgrading to title deeds, and then resulted in obviously rates having to be paid. In areas where there's no survey, that an automatic upgrade can't happen. You have to have a survey in place before a PTO could be upgraded. But I agree with Zinande that that raises all sorts of other issues, in relation to the rights and who holds what. There's agenda issues in that as well.
All right, thanks. We've got 6 minutes remaining. I'm going to cram in 3 more questions, but I'm not going to read them word for word. I'm just going to sort of give you the general drift of them. One is from Mahotla Sifuli, is asking what happens if the expropriation bill goes through? Does that mean that land could be expropriated that is vested in the Ingonyama Trust? The second one is from Dangel Midgley. Pardon me if I mangle your names. And it's about, is there any litigation? Has there been any litigation around the IPILRA, the Interim Protection of Informal Land Rights Act, and the Ingonyama Trust itself. There is another question, which I can't find now, which asks, what happened to the litigation that had started before the lockdown? And then the last one is the million-dollar question. Why is government protecting traditional leaders who are bullying people? This is from Baby Mahedisa. So let's take those as parting shots and any closing comments that you may have.
Okay.
Zinandi?
Yes, thank you. So the sort of coming into effect of the expropriation bill will not have an automatic effect on the land held in the Ingonyama Trust, because I mean that land was transferred and invested in there. So then that's a question around the Department of Rural Development and the state on like if that's something that they'd want to do. But the sort of expropriating the land from the Ingonyama Trust wouldn't really respond to the security of tenure issues that we've been talking about. So, and the expropriation bill itself isn't a response to the security of tenure issues that we've been speaking about. It isn't a silver bullet for land reform and sort of achieving and filling in the sort of responding to the problems that have plagued land reform since sort of its inception. So I think the thing that we need to be focusing on is sort of ensuring that the state actually passes legislation that complies with Section 25(6) of the Constitution and recognizes and protects the security of tenure and tenure rights of people. All these other issues really don't respond to that very core issue that people's rights to land are not recognized and are not adequately protected, and that where if the land vests in the trust, if the land is in the state's hand, those issues will still remain. And those are the things that we need to be sort of putting in place to ensure that we respond to them. And then the second question around litigation on IPILRA and the ITB. So there's currently, and this also ties in with that question around the litigation that was started a couple of years ago. So there's currently litigation that's against the trust related to their conversion of PTO rights and customary rights into leases, into the leases that I mentioned before. The question of converting ownership rights into leases without properly informing people and getting their consent of drastically changing their rights to land definitely implicates, and at the center of it are people's IPILRA rights. So there is current litigation in that sense that asks the question of how the Ingonyama Trust needs to be respecting rights that exist in terms of IPILRA, and how their policies of converting PTOs, of converting customary land rights into leases is a violation of IPILRA and Section 25(6) of the Constitution. And why is government protecting traditional leaders that are bullying? I mean, this is definitely a personal opinion, but I think that it's this misconception that traditional leaders are the way to access traditional communities, and that if you then in any way don't give traditional leaders what they want, or you hold them to account, or actually respond to what communities want to be dealt with in relation to the issues they have with traditional leaders, all of a sudden you are not going to be having access to that resource that is traditional communities, either for votes or either for sort of also easing access to traditional land for the purposes of mining and for the purposes of building lodges, of building office buildings and building like sort of residential things. So it's a twofold thing. Traditional leaders are seen as a way to get access to people's votes, and they're seen as a way to ease access to people's land, because if all you have to speak to are traditional leaders and then they sign these leases or they sign these agreements on behalf of communities, then there isn't sort of that actually having to do the work of speaking to individuals and seeing them as agents and as free agents, as holders of rights, and therefore being at the center of how their land needs to be dealt with. That's going to be too complicated. It's just easier to speak to one human being, pay him off, and not really have to be accountable to people that hold rights to land.
Zenande and all the panelists, I'm told the system's going to cut us off at 5 o'clock.
Okay.
So I should just quickly say thank you, all of you. I see Lerato still on the line. I didn't realize she was. So I'm sorry we haven't brought you into the conversation. I'm sorry we can't answer all the questions. Let me say thank you to everybody, to the panelists, and especially to the Nelson Mandela Foundation and the Hans Seidel Foundation. Thank you to Lark, and thank you everybody for joining us. We are hoping that we will continue this conversation. There are a lot of complicated issues that we need to deal with. The Ingonyama Trust is only just one of them, but there's a whole lot more to deal with land in light of the fact that there is the expropriation bill, there is a reconsideration of Section 25 of the Constitution currently being undertaken in Parliament. So with that, we are unfortunately going to have to end it here.
Thank you very much.
Thank you very much, everybody.